first sittings of the new fiscal year as a scene in Groundhog Day. We start over. So we had busy last year, and then we start from scratch this year. But we welcome you to the September 12th, 2022 settings of the 7th Court of Appeals in Amarillo, Texas. We had 2 cases for this morning. One went away temporarily, so we're down to this one. And we appreciate you appearing. And before we start, I'm going to ask our newest justice to do us a favor. And our newest justice is Alex Yarborough. If you have not met him, he just came on board last week, officially, so thank you. Could you shut those doors?
No problem.
Thank you.
New guy's already behind on the job.
And he will be monitoring. He's taking names, so he'll remember you. So do well. And Mr. Bailiff, it's good to see you again. So the one case we have for this morning is 07-22-00131-CV in the interest of CS and JV children. And we have an appeal from the state. Is the appellant ready?
Yes, Your Honor.
Okay, is the appellee ready?
Yes, Your Honor.
Very good. And of course, when you were given notice of the setting, you were also told each side has 20 minutes. Of course, the appellants have an additional 5-minute rebuttal. You're welcome to take the entire time, but you don't have to feel obligated to take the entire time. And what we would ask is, sometimes we do ask questions. Do not necessarily interpret our questions as indicating where we're going. Sometimes we don't know where we're going. But answer the questions as best you can, as clearly as you can, as succinctly as you can. Over the years, we found out that we can tell when somebody's just doing a soft shoe. So, don't do a soft shoe. Okay. With that, how do you pronounce your last name? Safadi. Ms. Safadi. You have the floor.
Good morning, and may it please the court, Rebecca Safavi for the department. This is really a pretty simple case. It's very straightforward. The statute says one thing, the trial court did another, and as a result, the trial court abused its discretion. So just to give a few highlights of the timeline to sort of put this in context. So in November of 2016, we have an order establishing a parent-child relationship out of Wheeler County. In January of 2017, also in Wheeler County, there's another final order that says that the grandparents are named the sole managing conservators of these children, and the parents are named as possessory conservators. In November of 2020, the department files a petition to modify under 262 in Randall County, and there's an order of protection granted that same day.
Well, that petition also says the department's going to transfer the case at that point as well, right?
Yes, Your Honor. It does, I believe it does mention a transfer. It does acknowledge that Wheeler County is where the last order was out of.
Wouldn't we have saved some time going through the process if the department had actually transferred the case when it said it was going to do it?
Yes, Your Honor, and I don't know, I was not involved at that stage, so I'm not sure where the wires got crossed and why it wasn't done at that particular point.
And you don't know of anything in the record that reflects why?
No, Your Honor, I don't.
There's also a paragraph in that petition that the court has emergency or home state jurisdiction under the UCCJEA. That doesn't seem relevant to me, but in the pleadings.
I apologize, Your Honor.
That's all right.
Yeah, I would agree that the UCCJEA does not apply here. That may have just been an oversight. So the next important date that we have is on May 4th, 2021. There's an initial permanency hearing order, and it sets out the dismissal date under 263-401 for November 8th, 2021. So we fast forward to October 2021, and the mother files asking to retain the suit on the court's docket, and the court does so. the new dismissal date is set for May 7th of 2022. So in March of 2022, final hearing commences, and the...
I know that the issue is jurisdiction. Is anyone contesting the fact that there was no trial within the 1 year plus 180 days?
I don't believe so, Your Honor. It was set for
So
April.
That's out of, that time period is not in play.
No. See, from what I understand from the argument that was made at trial, the argument was because we didn't do our transfer order before the 263-401, that we had lost jurisdiction and that extension order was invalid.
But the 180 days couldn't have been extended in November of '21.
Well-
Not that the trial that began occurred before the expiration of the May 7th or whatever date it was.
If I'm understanding your question correctly, our position is that the extension order that was done was valid, and that the court still had jurisdiction at that time to enter that.
Yeah, the Chief's question, I think, was there's not an issue that the trial occurred on time. That presupposes that the extension order in November of 2021 was valid.
Correct, yes. The first final hearing commenced in March of 2022. They vacated that order because the transfer had not been done. It was reset for April. It was going to start in April, but on that day, the relevant motion that we're here about today was heard and granted, and the case dismissed.
How would you interpret what the trial court was thinking when you dismissed the case?
Well, the trial court told us what they were thinking. I believe the way they interpreted the issue was whether or not they could extend the emergency jurisdiction so far as to, for that amount of time. So that the emergency jurisdiction lasts from, when we file our 262 petition all the way through.
So you had the Wheeler, and then you had Randall County. Wheeler had exclusive. Randall County they could have gotten the jurisdiction here before they transferred it here. They filed the extension. They took it past the 1 year. And then they had a trial. Court realized exclusive jurisdiction was in Wheeler. Set aside the trial. Got the case transferred. And then dismissed because he thought... Remind me of the trial judge again?
I don't know the trial judge's name.
Judge Jensen thought maybe that he needed to get the case transferred here before he filed the extension.
Yes, Your Honor, I believe that sums it up.
But then he goes on to say that if the department wanted to refile, this is after he's dismissed it, he wouldn't have jurisdiction under his theory.
I'm not sure how that would work, because he did file that transfer order, and so part of the department's position here is, so if we go with the idea that we cannot retain that jurisdiction until transfer, even under his rationale, his transfer order would be void, which doesn't make sense.
Okay, so is it the department's position that under 263.401 that they're still maintaining emergency jurisdiction until a final hearing?
Well, 262.203 tells us that notwithstanding 155.204, the motion to transfer is timely as long as it's done while the case is pending.
Right.
So, in theory, yes, the 263.401 would extend the jurisdiction until the case is no longer pending, which would be the final hearing.
Well, there was some argument made at the trial court level that the court basically just had jurisdiction to do emergency type things prior to the 1 year period.
Well, they have the jurisdiction to do not just emergency type things, but other temporary things. We don't have any case that's completely on all fours, but we do have a few cases that specifically mentions that under 262, the trial court retains jurisdiction to issue both emergency and temporary orders.
And the docket entry indicates that the temporary managing conservatorship was being continued. The department was being continued its temporary managed conservatorship.
Yes, I believe it does.
So, and the trial court has authority to enter temporary orders under 262.
Yes, Your Honor.
Does the document, let me rephrase the question in a different way. The docket entry, however, does not say how long the motion to extend is granted. It just says it's granted. And Mother's motion to extend doesn't say how long it's granted. So, can we infer that the jurisdiction was extended the entire 180 days, or do we say it extended 1 day because the court didn't tell us how long the time period extended?
Well, I believe because we have that dismissal date noted, the new dismissal date noted on that, the order that actually grants the extension, I think that we, take these things together and say that it was...
That wasn't Judge Anderson who signed that order, though, right? That was the associate judge.
You may be right. I'm not completely sure.
Does the associate judge have the same coextensive jurisdiction on temporary orders under these circumstances?
I know of nothing that would say they don't. But that's not an issue I have researched. I'm happy to supply supplemental briefing if the court would like, but that's not something I've looked up.
To me, it looks like, if you read the appellee's brief, the appellee says 2 issues control this appeal. First, I'm moving forward, whether a court exercising its emergency jurisdiction may extend emergency jurisdiction. And your argument seems to be the same thing. The court hadn't directly addressed the question, but the court stated, or at least the Texarkana court stated in dicta, that Chapter 262 authorizes a trial court to enter emergency orders and other temporary orders. Those both seem to focus on this time period of October 2021 when this docket entry occurred and when the order was signed by the associate judge. That seems to be the crux of the issue. Am I misstating that, or is...
No, I believe that that's correct. I think that if the transfer order had been done, before, we wouldn't be here today. So I think that you're right, is the issue, do they still have that temporary authority at the time that was done? Is
there any authority under Chapter 262 that allows the court to do that?
Well, I would say that it doesn't say, and we look at, for legislative intent, whenever we do statutory interpretation, and we talk about what the statute does say, but also what the statute doesn't say. And there are certain timelines in different parts of the Texas Family Code, but there's not one for transfer. Transfer specifically just says pending. And the legislature has revisited this statute as recently as 2019 and changed the language of that subsection, and still has not entered a specific time saying you have to do X, Y, and Z by a certain date. It doesn't mention 263-401. 263-401 does not mention transfers. So I think that we can imply, by the fact that they have not entered those requirements, that there isn't one except for while it's pending.
Well, but is that the case? Because under 155, let me look, it's under 155-001. It says, if a court of the states has acquired continuing exclusive jurisdiction, no other court of this state has jurisdiction of a suit with regard to that child, except as provided by, and then it includes 262 there. That indicates to me that there's a limitation on when Judge Anderson could exercise jurisdiction, except under the situations provided in 262. If there's no language authorizing Judge Anderson to do, or the associate judge to do, this notion of extending orders, doesn't that mean we're outside the language of what the legislature's granted for jurisdiction?
I don't believe so. Because especially if you look at other parts of 262, it specifically says notwithstanding portions of 155. So I think that if you take those things all together, it indicates that the legislature's intention was to make sure the department could continue to make those steps under 262, because a 262 case is going to be different than private case, say, that's brought specifically under just 155. So I think if you take those statutes all together.
What steps could the department make in the interim then?
Do you mean while we're waiting to transfer?
Is that the emergency orders and temporary orders?
Yes, Your Honor, and
So your argument would be if this extension order was an emergency or temporary order, then the court had jurisdiction.
yes, Your Honor, that's exactly it.
And dismissal was improper. Does the statute define emergency order?
I will have to double check that. I don't believe it does in this context.
Does it define temporary order?
Not that I know of.
Does 105 allow the court to sign an extension order as a temporary order?
I don't have the text of 1 and 5 in front of me, Your Honor, so I'm sorry, I can't answer that without reading that. But again, I'm happy to provide this extra research on how this all works together.
An emergency order, the word emergency in and of itself, you could find it, its plain meaning means something that needed to be done immediately, now.
And I don't disagree with that. However, if we were to interpret it in such a narrow manner, what would happen if, for example, we got to, month 14 of a case that had been extended before realizing there was a court of exclusive jurisdiction somewhere else? Does that mean that we would then have to go back and redo all of the hearings, status hearings, what if there was a Native American child involved, and there was a hearing to determine whether or not the child was eligible under ICWA, these sorts of things? To take the appellee's rationale would be to say we have to redo all of it.
So an emergency can arise from the failure to discover another court's involvement, that court having exclusive jurisdiction. In other words, if somebody screws up and fails to see that some other court has jurisdiction, and then they realize it relatedly, that realization can create an emergency.
I don't know that there's any case that has discussed that.
I'm asking you.
Yeah, I don't know the answer to that. I don't know that that is exactly the emergency that the statutes are referring to.
Would you, are you suggesting though that this is not necessarily an emergency situation as opposed to a temporary order situation?
I would say that maybe it's both.
Well, 262.204, temporary order in effect until superseded. So, under 262, the temporary order that was rendered in this case, according to that statute, is valid and enforceable until properly superseded by a court with jurisdiction to do so.
Correct.
So what does that mean?
I think that reinforces the department's position because, again, if you take what the trial court did and apply it across the board, that would sort of make any temporary order fall apart that was entered before that, leading to, again, like this nonsensical result where we would have to go back and start all over every single time.
Let me clarify, because there may be some words missing there. It says a temporary order rendered under this chapter is valid and enforceable. So does that mean that you have to find the source of that basis for the temporary order under 202? 262, as opposed to maybe a 105 order isn't valid for that period of time because that would not be a temporary order rendered under this chapter. Or it is rendered under this chapter, is the legislature really trying to say, in cases like this, when you have a temporary order, then they stay in effect?
That would be what I would interpret it as in cases filed under 262. That's how I would interpret that, just by the plain meaning of the language.
The department appeared to take the position, at least during the hearing on the motion to dismiss, that the court was correct in vacating the order. And so that appears to be a position that or at least agreement on both sides, that Judge Anderson did not have jurisdiction to at least render an order at that point.
The final order is what you're talking
The
about.
final order.
Yes, the March 2022, we agree, because the statute says while it's pending, and so the transfer had to be done while the case was pending. Final order would be not while it was pending, so he did not have jurisdiction to do that. He needed to transfer before that final order was done.
So what is your authority for saying that Judge Anderson could not have signed the final order? And I'm just trying to understand. You make a distinction between Anderson or the associate judge could somehow sign an order extending the time period, but could not sign a final order.
Under 262-203B, it states that a motion to transfer is timely as long as the case is pending. So if we get to the final hearing, entering a final order would mean it's no longer pending. So that transfer order had to be done while the case was still, before the final hearing.
Okay. Where does that leave us now? Suppose we agree with your argument. The dismissal occurred, I think, on the 20th of April. You had till May the 7th. That leaves us like 17 days of jurisdiction. Is that what we're here fighting about today?
Well, I think what we're fighting about here today is to ask the court to reinstate the case so we could have a new trial.
Right, but for how long, right? You've used a year plus 180 days, I guess minus 17, so you've used 163 days or so of your 180 extra 180 days. Does that mean Judge Anderson, the case goes back to him and the case can sit on the docket for 17 days and then it gets dismissed as a matter of law?
Correct me if I'm wrong, because I'm just trying to remember this off the top of my head, but I believe the Family Code gives us 180 days if it's remanded for a new trial, notwithstanding 263. I would have to look that up, but I'm fairly certain that there is a specific provision keeping in mind that we have 263-401. If it's sent back, you get more time.
Okay. Maybe. That's what
Yes,
I'm asking
I'll just have to double check
Yeah.
that.
And can you provide us with that site?
I will make sure that I provide that.
The opposing counsel has that.
Would you like that as a supplemental brief, or?
Included in a letter to the court, copy opposing counsel.
Thank you. And I believe that's about all of my time, so if there's no other questions, all right, thank you.
Counsel? Can you pronounce your name Michelson?
Yes, sir.
Thank you, sir. You've got the floor.
I'm in the middle of getting cataract surgery, and I was in such a hurry this morning, I forgot my hearing aids, so I'm in a fix. So, I think this case progressed as a normal case in the beginning. The 262 court took emergency jurisdiction of the child. The state did what it was supposed to do after the adversary hearing. It contacted the Department of Vital Statistics. The Vital Statistics Department in error said there wasn't a prior order or court of continuing jurisdiction when in fact there was. And I think the state was aware of that at the time that they modified the petition, because under the jurisdiction it says that court of continuing jurisdiction exists and that they intend to transfer the case. At some point that disappears. The case progresses as if it was a 155 court. And then I think Judge Anderson succinctly said that it's a question of whether the 262 court has the authority to extend its temporary emergency authority. And
your position is it's not. On page 37 of your brief, you say, because the transfer order was filed late in this case, the extension order under 263-401 was void because Randall County Court did not have jurisdiction to enter such an order. But there's no authority that I've read in your brief to support that conclusion as to why Randall County couldn't sign something as a temporary order to extend the time period. May not be able to hear the final case, I think everybody's in agreement on that. But why not be able to extend it to 180 days?
I think I just tracked with the attorneys that were involved, and I think their position was that, under the statute, the state has 365 days to enter a final order, or the case is dismissed. And,
Unless it's extended under 262.
unless it's continued, correct. And I think that's the crux of the issue, is whether, the appellee's, motion at that time to extend the case was valid, or if the court had lost, the 262 court had lost its, subject matter jurisdiction and therefore couldn't enter that order. So,
why couldn't the extension order be considered either an emergency order or a temporary order in your view?
I think that's the question. I don't think there, is any authority that I can find that, answers that question.
I'm asking you why. Because if the answer is yes, it is a temporary or emergency order, case over, isn't it?
Correct. I agree.
But you're up here not conceding that point, correct?
Correct.
So why do you think that point is wrong?
I don't have an answer for that immediately, so.
I think we've all done our own research on this one, and we've tried to figure this out. I haven't found anything, I haven't had a case directly on point saying, yes, 262 says you can do it this way. But let me walk you through at least my analytical process on this one, and see if you agree. We have to go back to section 101, okay, chapter 101, the definitional section, okay? And it says, suit, the definition of a suit. Suit means a legal action under this title, and we're under Title V here, okay? You would agree with me that a suit to terminate would be a suit under Title V?
Yes, sir.
Okay. We flip over to 105 then, which is the temporary orders provision. And 105.001 says, in a suit, a court may make a temporary order including the modification of a prior temporary for the safety or welfare of the child, including the following, bing, 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 and then it lists some other things. I think including means it's not limited to those 5 things on the list. If 105 says in a suit a court can make an order, but it doesn't specify it has to be a court of continuing exclusive jurisdiction, it could be a court, does that answer the question of what we're dealing with here, that the court may not have been able to sign a final, Judge Anderson may not have been able to sign a final judgment, but Judge Anderson could sign temporary orders, including the orders to extend the deadline for 180 days?
I agree with that.
Okay. I don't have any clear answers, and so that's one of the things we're trying to figure out.
Yes.
So when does the 262 court lose its emergency jurisdiction?
Well, I think.
Is it 12 months? The first Monday after the suit's been filed for 12 months?
I think if you look at 262 and the case law that attempts to explain it, it says a 262 court has authority up to the point of entering a final order. So I think a 262 has pretty broad range to enter orders. It just can't enter a final order. And I think part of the argument is the state's position is as long as the suit is pending, and the appellee's position is much narrower than that. And I believe Ms. Grant indicated that it was after the adversary hearing. I think if you take the broad position of pending, it leads to absurd results and considerable expense to the state, like we're here today trying to figure out, does the state have a point where it's required to transfer a case? It seems absurd that you could transfer the case just prior to trial. I would think that would come as great surprise to the parties and to the judge. So I'm not sure that's an efficient way of using state time or the appellee's time.
Certainly, the transfer of the case can be jurisdictional in the sense that without the transfer, Judge Anderson couldn't render a final order. But is it jurisdictional in the sense that if you don't obtain a transfer by a certain period of time, that jurisdiction vaporizes?
I would think so, because I think if you don't transfer the case, if the state doesn't make a motion to the court and the court doesn't enter an order, at some point it loses its jurisdiction because it can't enter a final order. So at some point it has to transfer the case if the case is to continue, or to continue to some resolution.
Do we need to answer that question if Judge Anderson had jurisdiction to make a temporary order on October the 29th?
I think the first question is, if he has authority to do that, it changes everything.
You would need a transfer order
No.
at that point.
Well, at some point...
Ultimately you would, but as far as signing those orders on the
Right.
29th, you would.
I agree with that. If he had the authority to extend the case, it's a moot point, I guess. I mean, he has the authority, and then at some point the state can transfer.
And that would depend on whether or not there's an emergency or temporary order.
Yes,
Within the statutory provision.
I would agree with that.
Because 263.401 provides that, assuming the trial court has jurisdiction, that it can make temporary orders
Yes, ma'am.
after it's been extended for the 180 days.
The way, well, that's from 262, correct?
263.401.
Oh, 263, okay.
Oh
To me, that sounds like a presumption of a 155 court where it can enter orders. I think that's where the tension is that the legislature seems to have created this distinction between 155 courts and 262 courts. And I think
Well, I think 262 gives the court where the children may be found the ability, when there is another court of continuing exclusive jurisdiction, to file the suit there.
yes,
155 doesn't deal with filing suit.
no,
It deals with the transfer.
yes,
Okay. But then we have a very specific provision under 262 where the actual court, 262 court, can initiate on their own motion that
Right.
transfer. And that trumps 155, doesn't it?
I'm not sure Trump in terms of who has more authority. I think the legislature says a 155 court is the end. I mean, once they sign a final order, they're the final decider.
Okay, so you're using 155 court to mean the court of continuing exclusive jurisdiction?
Yes, ma'am.
Okay, gotcha. I was thinking you were, I wasn't following you. Now I understand what you're saying.
I want to ask you another hypothetical question, something that just came to my mind. Suppose we have a situation, child is found abandoned in a county in which we don't have a continuing exclusive jurisdiction, okay? So in this case, child may live in Wheeler at the time the court signs the order giving them a continuing exclusive jurisdiction, and we find them later on in San Antonio by themselves, all right? Department steps in and says, we found this child, we're trying to figure out what's going on, you need to sign orders for protection of the child, okay? We're okay so far, right, with the San Antonio court exercising jurisdiction under 262. That court in San Antonio says, not sure where the parents are, I'm going to order the child to live with the grandparents. We've identified the grandparents, going to say the child can live with the grandparents subject to these terms and conditions, right? You come back, you have regular wellness checks or allow the department to check on you, et cetera. Are those temporary orders?
I would think so.
They're not expressly listed in 262.
No.
Where's the source of the authority that allows the San Antonio court to do that under those
I'm
circumstances?
not even sure 105 would give you that authority. So, I don't know. I think it's implicit in the court's ability to do that.
I mean, you wouldn't disagree that,
No.
you wouldn't say a court was wrong in
No,
saying, no,
no.
you can't order the child to live with the grandparents and you can't check on the child.
No. I think the only point I would have a disagreement, and I think the other appellees disagreed, was that the court entered a final order, and it didn't have the authority to do that. So I think up to that point, it's a question, did it exceed its temporary orders in not transferring the case, or was it within its realm to continue the case? I think that's an important question to answer that I don't have the answer to.
If the department concedes that the trial court was correct in vacating the final order, but the department's complaint on appeal is that the trial court erred in dismissing the case for want of jurisdiction, is that a different issue on appeal? Like, everybody can say, yeah, Judge Anderson couldn't have signed the final order at the time, but he shouldn't have dismissed it.
I think dismissal is the proper remedy. I think once you've exceeded the subject matter jurisdiction, I think it's a nullity, and I think dismissal is the proper result. And in fact, I think you penned in GXH about, need to come to appellate court to ask for a case that's already dismissed. So it's...
What about a situation where, like maybe what we've got here, where Judge Anderson says, you know what, I don't have jurisdiction to render a judgment terminating parental rights or addressing that, whether I'm granting or denying it, but then a transfer order comes in, does that now give, I know it doesn't vest him with continuing exclusive jurisdiction, but does that give him now the power to render a final judgment if he wanted to reset the case, assuming that there's enough time to do that?
I think if the state had, under 203, transferred the case prior to the final order, I think Judge Anderson would have the authority to enter a final order. I think the court ran afoul when it didn't transfer the case prior to the entry of the final order.
But that order was vacated, wasn't it? The termination order was
Yes.
vacated.
Yes.
So we don't have a final order. The case was transferred, I think, April...
It was April the 16th, and the motion to dismiss was actually filed on the 17th.
Yeah. So when the court heard the motion to dismiss, the case had been transferred to
That
Grant
day.
County, right?
That day.
Okay, so wouldn't the court have jurisdiction then?
I'm not sure the court was aware that the transfer had gone through. I'd have to go back and look at the transcripts. But I know it was at that time.
Does it matter whether or not the court's aware?
Well, I think it's important to, if the court is aware it has subject matter jurisdiction, if it's exceeded that, I think that's...
Subject matter jurisdiction dependent on the knowledge of the court or just on the existence of jurisdiction?
I think it's a
Order that gave it jurisdiction.
I think it's a combination of both.
Yeah, I think the record will reflect that the case was transferred from Wheeler County at least by March the 16th.
It was...
And this was on I'm sorry, March, yeah. And this was a hearing on April the 19th, because that was also the date of the final hearing.
Yeah, I apologize, you're right, I was 1 month late. It was,
Okay.
my understanding is the transfer certificate was received on the 16th of March. The father's motion to dismiss was filed on the 17th of March. The mother's motion to dismiss was on the 14th of April, and the hearing took place on the 19th of April. So by the time the hearing took place, the transfer certificate had already been received a month and 3 days beforehand.
I think at that point, I think Mr. Barfield and Ms. Grant argued that because the trial court had exceeded its authority by entering an order, it didn't have the authority to enter, that it voided the case. And I think that's their position, is that because appellees were harmed by that entry of the order when it should have been transferred.
Well, I think I would be in agreement with them if that had become a final order at that point and there had been an appeal from that point. I think I would have agreed with you that the court didn't have jurisdiction at that time. But we know from a bunch of cases that when the court vacates its order during the time that it's got plenary power to do so, then that's the effect of keeping the case on the docket, but we don't have an order. And I think that's what we're trying to figure out is, okay, so now there's no order. Now it's pending the same way that it was before trial began in March. Don't we still just have Judge Anderson operating under the same jurisdictional basis that he did until the case got transferred? And when the rest of the case got transferred, then he could do something. But rather than do something at that point, he dismissed the case.
I think in plain language, for me at least, the case starts off normally, then you have this huge mess in the center, and then the case resolves towards normalcy again. It's doing what it's supposed to do. It has the authority and it's making orders. But what do you do with that mess in the middle? Does that have harm to the appellees, or is there no harm to them? But to me, that center part is really significant, how to address that issue, because it includes, is there a transfer time? I think if you look at the straight statute where it says pending, I mean, that can lead to absurd results. You shouldn't be transferring the case in the, just prior to trial.
But isn't that up to the legislature to resolve to set a deadline?
I'm sorry, I didn't hear you.
Isn't that up to the legislature to resolve to actually set a hard and fast deadline for the transfer as opposed to pending, which is pretty broad?
I agree. I think that's where the tension is. I know there's case law that says that courts shouldn't be in the position of legislating. I agree with that. But at some point, the courts need to provide some guidance of what pending means, because I think otherwise we have other cases that wind up here because nobody knows for sure what that means, when it should be transferred.
Go back to one of the questions that Justice Doss asked opposing counsel. Assuming we were to say the trial court erred in dismissing, what do?
I'm not sure I understand your question.
Assuming we say the trial, well, go on. It was your question.
If we say that Judge Anderson may not have had jurisdiction to render a final order, but that once that got vacated and the case got transferred to him, he did have jurisdiction to do something at that point, and that he committed error in dismissing at the time that he dismissed, what do we do now? Do we remand the case? What would the remedy be, at least from your perspective?
I think from my perspective, just to keep things clean, I would affirm the dismissal and begin again.
Well, where would you begin?
With a new petition, I think.
In which court?
In the 262 court. I think at that point, they have authority.
Well, but he had that authority when he signed the order of dismissal.
That's the question, and that's what the appellees are arguing. I think Mr. Barr, Mr. McLaughlin, and...
Let's go back to the question and the facts that Justice Doss posed. Let's say we do hold that Judge Anderson was wrong in dismissing because he had jurisdiction. Okay, let's start there. And we reverse the dismissal. Where do we go from here? We remand for a trial, we remand for further proceedings. If we remand for trial, do we tell him he's got to have it within 17 days? Does he have to have it within 6 months? Does he have to have it at all? What do you think?
Well, I think if you remand for trial, it doesn't give adequate time to prepare, either from the court side or from the client side. I think that's pretty quick.
Which is pretty quick, 17 days, 6 months, forever?
Well, I think that question presumes there's absolutely no harm in what the court did. And there's no harm to the client, there's no harm. And so you can proceed on as if that didn't occur. And to me, what that occurred needs to be answered, because otherwise we're going to wind up with the same situation ultimately. Somebody's going to do the same thing.
Thank you, Counsel, your time's expired.
Thank you. Thank you.
Book?
Thank you. I just wanted to address one or two quick points.
Oh, let's start again, hold on.
It's a really long one.
Yeah.
Yeah, I don't have that much to say. So,
And we're not gonna give you that much.
all right, there we go. All right, so I wanted to point out that Applee keeps saying that emergency jurisdiction would disappear, quote, at some point. And they've not been able to tell us at what point that might be, because like I've said before, the statute doesn't tell us, emergency jurisdiction expires on, XYZ date. It just simply doesn't say that. It says that transfer has to be done while the matter is pending. It was done while the matter was pending because it was done a whole month before it was
You
sent.
take advantage of the emergency jurisdiction when you caused the problem. You caused the problem by not transferring it when you knew you should transfer it. You, not you, but
I
yeah, the
understand.
department.
I'm
Is
not
it
sure-
really an emergency when you knew to transfer it and you don't do it until the last date, and then you go, oh, it's an emergency?
And I do understand that can create some problematic issues. We don't want people running around taking advantage of vagaries in statutes, just to accomplish.
One potential problem that I've got with it is that when you've got a case with a court with continuing exclusive jurisdiction, there's at least an understanding that that court is familiar with who the parties are, familiar with the kids involved in the case, familiar with the background set of facts, and if you withhold the time period for transferring that case or giving the Wheeler Court the opportunity to hear that case, you've got another judge who doesn't have any familiarity maybe with what's going on, who's hearing this case anew. They don't have the benefit of the record. They don't have the benefit of the testimony or exhibits from previous times. And I think, at least from a public policy perspective, is hold on. The government is the one who's got that burden to take, before you take rights away from parents, that the government's got to be careful at ensuring that we at least get that opportunity to be heard in front of the right court.
And I think that is an important policy thing to keep in mind. I think if you look at the statutes as a whole, the legislature seems to have already considered that, because they have considered that tension between 155 and 262, and they specifically address it in several places in both 155 and 262. And they've had the opportunity to add in those specific time frames, and they haven't done it. And I think that we have to take that for what it's worth. And I understand that Applee is saying that we need to, get some guidance from courts, but, what does that mean? Does that mean that the court makes up, well, it has to be done in 30 days, and 60 days, and 90 days? That's problematic when the legislature has declined to do that specifically, and has declined as recently as 2019. We're not talking about a 100-year-old statute that's just sort of archaic.
Well, certainly there's not a common law power to divest parents of their rights. That right, if it exists at all, is going to be found in either a constitution somewhere or in statutes. So in the absence of legislative statements on this question, does that mean that our hands are tied as a court? We don't get to consider those public policy related issues?
I don't think that that's accurate. I think that, courts absolutely are in the position to address policy issues. I think the danger we face here is by taking a statute that very clearly has stated, here's when you're supposed to do it by, and changing it.
And that deadline's pending.
Yes, Your Honor.
And we assign that word its plain meaning.
Before the final hearing. Yes.
The order extending was it just an order extending the period, or did it contain other things like during the interim, the child or the children will remain in the custody of XYZ, et cetera, et cetera?
I believe it was a permanency order that extended.
Continued the temporary managing conservatorship and different, rights and duties of the parties, I
Yeah.
think.
In theory, it would have also, laid out the findings for extraordinary circumstances and best interest of the
So
children.
to that extent, there are aspects of it that would fall within the general concept of temporary orders in place in order to take care of the child.
Yes, and that was actually exactly the next part of my notes, is I, wanted to say that a 263-401 order absolutely requires temporary findings about what is going on temporarily during the case.
Does that make it a temporary order because it requires temporary findings?
In the plain meaning, yes, I believe it could.
I mean,
Especially
I
in,
guess it's temporary in the sense that an extension isn't a final order. It's gonna have a terminal date if it expires.
exactly. It's temporary in that it's not a final order. It does not dispose of all of the issues before the court, and therefore it's temporary.
Thank you, Counsel.
Thank you.
Your case is submitted, and you are free to go, and want to thank you for coming up here to present your argument. It's an interesting issue. And, hopefully it'll never happen again. But we find that things that are unexpected do happen again, so. We'll be in recess, and you are free to leave. Thank you.